right, good morning, everyone. Thank you all for joining us today. My name is Madison Looper, and I am an article editor for the Wyoming Law Review editorial board. It is my pleasure to introduce Professor Sam Kalen, a distinguished scholar, teacher, and leader whose work bridges the worlds of law, policy, and the natural environment. Currently, Professor Kalen is the first Robert H. McKinney Family Chair in Environmental Law at the University of Indiana McKinney School of Law. Professor Kalen has been the William T. Schwartz Distinguished Professor of Law and Associate Dean at Wyoming College of Law. He is a recognized expert in environmental, public lands, and natural resources, as well as energy and administrative law. At Wyoming, Professor Kalen founded and was then the co-director of the Gina Guy Center for Land and Water Law, and that very center is one of the sponsors of today's symposium. Before joining academia, Professor Kalen practiced law in Washington, D.C., including at the Department of the Interior's Solicitor's Office and in private practice where he worked on many of the same issues. His insights into environmental governance, federalism, and the role of law in preserving the Western landscapes makes him the perfect voice to help frame his discussion on the Clean Water Act Wetlands Program. If any audience members have any questions during Professor Kalen's presentation, please feel free to use the QR codes. There's some on the table, and we'll answer those during the Q&A portion of his presentation. Please join me in welcoming Professor Sam Kalen.
Well, thank you and welcome, and I want to really express my deep thanks to the Wyoming Law Review for putting on an incredible symposium. I know they worked really hard, and I think this is just a sort of a great exhibition of how good they have been. So I really appreciate all the hard work and effort they put in to be able to present these topics here today. And so with that, I want to begin by avoiding giving you too much of a spoiler, but in the spirit of storytelling, I guess, you might have two federal employees who lay murdered on property presumably being developed in violation of the Clean Water Act. And should those federal officials from the Environmental Protection Agency have been there? Was the land even subject to the Clean Water Act Section 404 wetland program? Or possibly, was this yet another version of what confronted an Idaho couple back in 2012, with this time in the central reaches of sparsely populated Wyoming? After all, the Idaho couple, Mr. and Mrs. Sackett, argued that their property just 300 feet from Priest Lake, Idaho, was not a wetland capable of being regulated by the United States Army Corps of Engineers or the Environmental Protection Agency. They pressed their cause all the way to the U.S. Supreme Court and successfully established that they could be able to challenge the issuance or the regulation of a Clean Water Act to them. But if so, why then, in 2013, would someone murder two federal agents purportedly enforcing the act, rather than simply accessing our judicial system? And of course, today, we now know that the Sackett's property escaped the Section 404 program. That might also be true for the 2-acre lot near Dull Knife Reservoir, Wyoming. Yet that result might not have seemed likely in 2013, when the eyes focused on Butch Robertson and whether he murdered the agents. Or so the reader begins to wonder as the pages turn in Breaking Point, the masterfully written and penned fiction novel involving Joe Pickett by C.J. Box. Breaking Point might be fictional, but not so the Sackett case, nor, by the way, the story now unfolding once again in Idaho, this time with Rebecca and Caleb Link's property in Bonner County. According to the Pacific Legal Foundation, the group that represented the Sacketts and now the Links, these Links own about 4.7 acres near a small city of Kitani. And on paper, according to the Pacific Legal Foundation, they have owned the land for 5 years, but it has been in the Caleb's family for 4 decades. The land is zoned agricultural, and it is basically land that they want to be able to develop. They bought the land quite some time ago. They argue that their property ought not to be subject to the Clean Water Act. That case is going to be the sort of similar one that's going to unfold just like with the Sacketts, or maybe possibly with the case involving Butch. But whether or not whether or not on the pages of fiction, there might be a hidden animating narrative, if you will, about the 404 program and the nation's attempt to arrest the loss of wetlands. So that was sort of my effort to try to avoid a spoiler and give you sort of a sense, if you will, about the relationship of the book that I'm going to be talking about, but really the Sackett case and the Clean Water Act and how it sort of interspersed with our conversation today. So if we start to take a look at, if you will, oops, the mic's not working. If we start to take a look at the wetlands program, and I'm going to start by noting that my objective here is to give you more of a narrative of what really ultimately led to the Sackett decision in 2023. The Sackett decision is perhaps one of the most significant environmental cases that we've seen issued by the Supreme Court in several decades. It has been written up in a number of different law review articles about how and whether or not it will reduce the scope of Clean Water Act jurisdiction. So for those who are in law school, it's one of the most important cases that we study today. It also illustrates something about another principle about statutory construction. So as we begin to take a look at, if you will, the Sackett case, the Sackett's property was roughly 300 feet from Priest Lake. Priest Lake is considered a prime area in Idaho. It is a highly valued recreational area. The property around Priest Lake is a known wetland area. The Sackett's property, if you take a look at my sort of attempt to give you a diagram there, fed into Priest Lake in a number of different ways. So what you can see, and I guess if I walk away from the mic, that's not going to work. But what you can see is that there is an ability of water to go from the Sackett's property on the surface all the way to Priest Lake, but there's some barriers in between the Sackett's property and Priest Lake. Also, we have studies that suggest that there was an underground flow of water from the Sackett's property to Priest Lake. Finally, it's worth noting before I get into a little bit more about the Sackett case, most of the Sackett neighbors, the Sackett's property neighbors, they had obtained a Section 404 program under the Clean Water Act, so they had went through the permitting process. The Sacketts decided not to do that, and just to give you a sense about what the property looks like, here you have a couple slides that'll show you what the property looks like. There's that one, and then that one. And there's another slide. So these are all from different angles from looking at where the Sackett's property is. And then that sort of gives you an idea of what we're really talking about. And there's a lot of homes around here, but you're talking about a known wetland area up there. And arguably, according to the EPA, the Sackett's property was connected to the Kalispell wetland area, and so it was called the Kalispell complex of wetlands in that area. And so that's why EPA wanted the Sacketts to get a permit under Section 404 of the Clean Water Act. So with that, let's take a look at what we're talking about. The Sackett case involved a simple statutory construction question. The issue is, under the Clean Water Act prohibits the discharge of a pollutant through a point source by any person into quote-unquote navigable waters. So what do we mean by navigable waters? Well, Congress defined navigable waters as waters of the United States. So here you can see, if you will, the statutory definition. Then in 1977, there was an amendment to the Clean Water Act, and in that amendment, in 1344G, what Congress decided to do was to allow states to administer aspects of the 404 program. But in doing so, they carved out an exception. That exception was that they did not want states to be able to regulate and issue permits for what we call traditional navigable waters. And I'll get into that in a little bit. But that was a carve out. And in carving out state jurisdiction, what Congress said is, by the way, we're going to include, and you can see it up there, we're going to include adjacent wetlands. So Congress wrote into 1344G this notion of obviously suggesting that adjacent wetlands could not be regulated by the state for traditional navigable waters, but instead the theory was that it would be regulated by the federal government. So with that said, we have tried and had litigation for quite some time trying to figure out whether or not wetlands are jurisdictional under the Clean Water Act's definition of waters of the United States. So it's worth, though, appreciating at the outset that any discussion about the historical narrative surrounding this wetlands program and the perception of wetlands has to appreciate that our perception of wetlands has changed dramatically over the years. And we're going to get to, where'd my little slide go? Now, I thought I had a slide somewhere around here of the swamp thing, but it might come up a little bit. But, so we've had this perception of wetlands for quite some time, and it has changed. We originally thought, obviously, wetlands were really things that we had to eradicate, and now we think that maybe they're important. So first thing to think about as we talk about the history of the wetlands program is perception. But then the next thing we want to think about is, how does that perception play into a narrative? We see books written that might discuss, if you will, wetlands. And obviously, Breaking Point is a great example. It's better than the ones that I'm going to mention now. But we have seen wetlands discussed in Princess Bride, one of my wife's and my kids, I think, best movie. But the wetlands there are portrayed with giant rodents. So it's a perception the wetlands are really bad because they house, really large animals. And you have, just to be clear, for those of us, many of you might be too young, there was a weird TV show that my wife also always watched called The X-Files. And X-Files, they had wetlands that were creating, obviously, some really strange events, if you will. So the public does get sort of a perception from, if you will, the popular media and the narrative. And it's interesting to sort of take a look at that evolution of how we look at wetlands. But at least a scholar in lieu of X-Files, or at least the Hollywood, Royal Gardner, who's written a couple books on the wetlands program, explains in a book called Lawyers, Swamps, and Money. I think there's a song he's trying to go off of, but hey, a character, he observes that, we used to have swamps, only the EPA made us to hate calling them wetlands. So, that's sort of where we want to begin. But, as we do and engage in our discussion, I want to at least point out that in 2001, EPA described wetlands, and this is in a settlement policy, as the following, and why EPA needed to exercise, if you will, enforcement authority. They say that we need to deter violations and remedy any harm caused by such violations because the necessity occurs and has become especially evident with respect to the discharge of dredged and or fill material into the waters of the United States, particularly wetlands or other special aquatic sites. And it goes on and says, wetlands act as natural sponges, providing flood protection and storm damage control and facilitating groundwater recharge. They furnish habitat for myriad plants and animals, including many endangered species. And they provide billions of dollars to the national economy each year from the fisheries and recreational activities such as hunting and bird watching. Wetlands also perform a vital role in maintaining water quality by trapping sediments and other pollutants before they reach streams, rivers, and other open water bodies. And so the policy sort of reflects, if you will, the general idea that has been really prevalent, at least since the early 1990s, about why we take a look at protecting today wetlands and why we may no longer look at them, if you will, along the same lines as maybe the, if you will, X-Files or the movie or Hollywood looked at them. So now I really want to, though, begin. Finally, I'll get to where I need to begin, with a beginning discussion of, if you will, our property rights dialogue and exploring the dimensions of when the Corps' application of the program might implicate a constitutional takings. Courts and parties confronted another dimension of the program, as that is when something would constitute an addition of dredged or fill material under Section 301 and 404. And you're going to see in a bit how the sort of narrative of the program evolved. But before we get there, I really want to take a look at right up there. For quite some time, wetlands have been regulated. Wetlands that are neighboring or adjoining, if you will, have been regulated under the Clean Water Act at least since 1977. So when we start to take a look at what ultimately happened with respect to wetlands in the Sackett case, it's important to appreciate that definition has been there for quite some time. And we've been regulating, if you will, wetlands. So here we have the Sackett's property once again. And when we take a look at the Sackett's property, the real issue is whether or not those adjacent wetlands right there are going to be regulated under waters of the United States. And so when we get to the Supreme Court Sackett case, we get a majority opinion by effectively Justice Alito. And, you know, the way in which Alito starts his opinion is going to be quite interesting, because we're really trying to understand as lawyers, what does navigable waters mean? But Congress defined navigable waters as waters of the United States. So are waters of the United States a term of art? Is the phrase navigable waters a term of art? You know, there have been a lot of issues associated with the concept of navigable waters. As many of us know, the idea about navigability or navigable waters comes up in the constitutional context. It surfaced early on in terms of understanding the scope of the Commerce Clause. It was part of the, this really, you have to be right in front of it. You know, early on in the Constitutional Convention, the idea about whether or not we were going to allow regulation of the Mississippi, that was paramount amongst the discussion. So navigability was really key, obviously, at the time of the founding. But we have other areas where navigability came into play. When states enter the Union, they are on an equal footing with all the original 13 states. When the state, therefore, enters the Union on equal footing, they get title to the submerged lands, that those are navigable waters, if you will. So navigability gets tied to the equal footing doctrine. Early on, we also had navigability tied to the scope of admiralty jurisdiction. So in three primary areas, navigability has a historical, if you will, connotation. We also had, in the late 1800s, the Rivers and Harbors Act in 1899. That statute applied to traditional navigable waters. Those are going to be the sort of navigable waters that we traditionally have thought about under the Constitution, that were going to be navigable, in fact, or reasonably susceptible to be made navigable, if you will. But then we had a lot of legislation since 1899. That's not surprising. And, you know, so we could go through, and if I had a lot of time, I could bore you to death by going through all the history that led up to the Clean Water Act. But it's important to appreciate that by 1972, it became clear that we had to, the Congress at least decided that states were not regulating sufficiently the efforts to control pollution, or at least discharges that were affecting pollution in the nation's waterways. So that's what ultimately led to the 1972 Clean Water Act. And in that statute, that's where we saw the language navigable waters and the definition of navigable waters as waters of the United States. The legislative history, at least then, sort of suggested, if you will, a different approach toward navigability, that it wanted to extend or enlarge the scope of navigability. But, you know, the original regulations that were issued by the Army Corps of Engineers at that point were really limited. And so in a lawsuit that resulted in a decision against the Corps, the lawsuit concluded that the Corps' effort to constrain the Clean Water Act to only traditional navigable waters was wrong, that it had to go back to the drawing board and draft broader regulations, i.e. expand what it thought were going to be navigable waters, if you will. So with all that said, that's sort of the history. Then let's go back to how Justice Alito really began to take a look at, if you will, answering that case, or answering the question. So the first thing he had to do is take a look at the Supreme Court precedent, if you will. That precedent started in 1985 with a case called Riverside. Riverside was an adjacent wetland, and the question in Riverside was whether or not that adjacent wetland was jurisdictional. But it was adjacent to a traditionally navigable waterway, and all 9 justices agreed that a wetland adjacent to a traditionally navigable waterway was going to be jurisdictional. But, you know, we're going to get into a little bit more of the nuances at the time of the 1985 Riverside case in a second. But the next major case after that was going to be the solid waste, or the Swank case that we talk about. And the Swank case, really, I love it, because if you talk about law reviews getting cited, it's the only time I've ever been cited by the Supreme Court is in the Swank case. So I really like the Swank case, but you know, it's sort of useless now. But with that said, you know, in the Swank case, the question was whether or not a certain tract of land in Illinois that was going to be used really as a dump for folks out of Chicago, where it was going to be jurisdictional under the Clean Water Act. And originally there was not going to be any problem with this use of this land, but then there were some birders who raised some objections that said, hey, look, you know, there are migratory birds that land in this area, and your regulation that you issued has a preamble. Remember that old regulation? We have a preamble in there, and that preamble says that lands that are used by migratory birds, or wetlands that are used by migratory birds, are going to be jurisdictional under the Clean Water Act. That became known as the quote-unquote migratory bird rule, but be careful, it's not a rule, it was a preamble. But with that said, the question was whether or not these types of areas that could be used or susceptible to being used by migratory birds was going to be jurisdictional under the Clean Water Act. And in the Swank case, the court said no. Okay, that raised a huge question at the time about, okay, was that going to also limit the scope of, if you will, the, let's say, isolated wetlands throughout the country? There was a huge, if you will, initiative around the time of the Swank case to try to figure out what the Swank case really meant. But let's jump to the next case. So after that, after the court rules that you can't regulate land simply because migratory birds might land there, the court then looks at the Rapanos case. And in the Rapanos case, it was another one of these instances where the wetlands were separated by berms, and I'm really summarizing these fairly grossly, if you will, but it was separated by berms, and the question was whether or not the Clean Water Act addressed that kind of land. And the answer, according to the court, was split. So you had Justice Scalia indicating that those types of wetlands would only be jurisdictional if they were relatively permanent and had a surface connection to traditionally navigable waters. But you also had Justice Kennedy. Justice Kennedy issued an interesting opinion that said, no, we can also regulate those lands that have a quote-unquote significant nexus, if you will, to traditionally navigable waters. Where did Kennedy get this language about significant nexus? Well, first of all, and I have written on this, he made it up. But he actually was trying to use the concept from the Riverside case, because in the Riverside case, when the Supreme Court said you could regulate adjacent wetlands, the Supreme Court used the language about hydrologically linked, or hydrologically connected, that there's a hydrological link between wetlands and jurisdictional waters, and as a consequence of that, really what Kennedy was saying is significant nexus reflects that necessary hydrological link, and that's why he thought you could regulate adjacent wetlands that are, if you will, have a significant nexus to traditionally navigable waters. Okay, fine. So that's what happens in Sackett. In Rapana. So you have two tests, if you will, the relatively permanent as well as the significant nexus test. We'll see in a second, you get a whole bunch of activity after that. Ultimately, when we get to the Sackett case, the Supreme Court and Justice Alito has to address whether or not to keep that significant nexus test. And the answer, according to all of the justices, is no. Okay? No justice supported in the 2023 Sackett case keeping the significant nexus test. Okay? What they all did was then issue various opinions, with Alito issuing effectively the majority opinion. And what Alito did in his majority opinion is fairly interesting. Because when we look at Alito, we have two questions. Our first question is, how did Alito arrive at his conclusion? The second question I want to address is really, why did he arrive at that conclusion? So the first, at least, question is more easily answered, if you will. The first one is, Alito understood that navigable waters was defined as waters of the United States. Fine. But then he went in and said, waters of the United States is constrained by the term navigable waters. And he looked at, if you will, navigable waters and really concluded that we want to shrink the scope of the Clean Water Act and the scope of adjacent wetlands. And this is where Alito did something really unique for those lawyers. He created a canon of construction. It's good at what we typically now, at least amongst law professors, useless for a lot of practitioners, but whatever, is he said that there's effectively a pop-up canon of construction. So if, in fact, a understanding of a statutory term like navigable waters or waters of the United States might affect private property rights, we need to have a clear statement by Congress that we want to affect private property rights. And so you've now got folks and scholars across the country sort of talking about whether or not you have this clear statement rule as a pop-up canon of construction. The other thing that Alito did is he made a nod toward Justice Scalia's opinion in the Swank case. What Justice Scalia said in Swank is, wetlands is a land use issue. Land use issues are traditionally done at the state level. And before the Congress really can usurp their functions or roles of a traditional state, if you will, program like land use, we also want to see, if you will, some clear congressional guidance that there's an intent to do so. And that's part of what we also call a federalism type canon, if you will. And so Justice Alito had those two canons, and he had some other sort of justifications. You can read my article that goes into some of that. But he had some other justifications that try to illustrate why he thought navigable waters, i.e. waters of the United States, would be narrowly constrained, and it would not include all adjacent wetlands. They had to be immediately abutting, if you will, and he also talked about the need for a surface connection. So he dramatically shrunk down, if you will, the scope of the Clean Water Act's jurisdiction over wetlands. What we also saw in his opinion, was the beginnings of an effort to shrink further, I think, jurisdiction of the Clean Water Act, because both the way in which Justice Alito wrote his opinion, as well as the way in which Justices Gorsuch and Alito wrote their concurring opinion, is really interesting, because both Justices Gorsuch, and Thomas, the way in which they wrote their concurring opinion, it really focused on navigability. It went through the concept of navigability from a traditional perspective, and it really was suggesting that the Clean Water Act is tied to traditional navigable waters. There was almost no suggestion in the history that it was ever tied to traditional navigable waters. And in fact, the Clean Water Act was amended in 1977, and the legislative history talks about the intent of Congress to regulate the nation's waters to the extent that it could under the scope of the Commerce Clause. So it was intended, arguably, at least according to some congressional history, to be read broadly. And both Justice Alito in the majority opinion and Justices Thomas and Gorsuch in the concurring opinion really ignored aspects of that and shrunk the scope of jurisdiction. Okay, so fine. Well, what about Justice Kavanaugh? So Justice Kavanaugh wrote a more interesting opinion, if you will, and this is something for at least a lot of litigators to think about in terms of who you're writing for now at the Supreme Court. Because what Justice Kavanaugh did is he actually looked at what are adjacent wetlands. He recognized that in 1977, Congress did what I had talked about before, put in language that directly talked about adjacent wetlands. And so he said basically that reflects an intent to regulate adjacent wetlands. And so it's important to appreciate that both Justice Kavanaugh as well as the other liberal justices agreed with Kavanaugh that in terms of the language of the Clean Water Act, it did apply, if you will, to adjacent wetlands, not just to those wetlands that were immediately abutting with a surface connection. With all that said, all justices agreed that the Sacketts won. Okay, not one justice dissented in the case. So, and there's interesting reasons that one could go into about why. So, okay, fine. That's the Sackett case. The significant nexus language or use as a test under the Clean Water Act is gone. The majority opinion now requires under Sackett's 2023 decision that you have to have a continuous surface connection, and we're going to see ultimately how that all unfolds. You know, a couple significant things first about the decision before I go on to the narrative is that it clearly illustrates a different approach towards statutory construction. It's looking at these canons like the pop-up canon on property rights. We don't know whether or not that's going to get used again or not, just to be honest about it. It further illustrates the use of a federalism canon. You know, but all those are really good legal issues. And I don't really care. We're talking about stories, right? So let's talk about stories, okay? Let's talk about why probably Alito did what he did, okay? And good luck. What? Oh, there's my swap. Yeah, I had another one on swap thing. I guess, I know it's complicated, but this is important to think about because the why to me is more important than what happened. The why is a narrative about the Clean Water Act program. This narrative about the Clean Water Act program is just unfolded as well as in the narrative about the National Environmental Policy Act. It's going to soon unfold. It started a long time ago, but it's been delayed on the application of the Endangered Species Act. So with all that said, I'm going to go quickly to sort of describe what this narrative is. And it really began, if you will, and I'm going to turn this so I can see. It really began in the early 1970s when the property rights movement began to get in earnest. And you saw here, for example, one property rights organization started in the early 1970s. The Institute for Justice is another one that started in 1991, and they were focusing a great deal on property rights. So what we began to see is, after that occurred, the wetlands program became sort of the poster child for a lot of these groups. And I will admit, I was in private practice at the time. I actually represented developers. I even went to one White House meeting on the wetlands program for developers. So you saw the beginning of a huge political movement associated with the wetlands program and private property rights. So what that started to unfold is amici briefs in the U.S. Supreme Court talking about the impact of the wetlands program. So you saw that in a little bit beginning in the Swank case. But after Swank, it really exploded. Because in the Swank case, when you had basically the Supreme Court saying you can't regulate migratory bird or areas where the migratory birds might land, what about isolated wetlands? So you started to see states across the country think about whether or not they wanted to regulate, how we were going to regulate isolated wetlands. And shoot, I don't have enough time. But anyway, can I get like 2 more minutes? So with all that said, in each one of these cases, you began to see, if you will, amici briefs talking about the cost and timing of going through the wetlands program. So the amici briefs language got translated into the Supreme Court opinions. And, also, by the way, on page 104 of the C.J. Box book. And so it's reflective of really the narrative that, yes, and I will admit I was part of this narrative at the time, it really was a narrative about how this program was impacting private property rights. That became aggressively, if you will, presented in each subsequent case, so that by the time of 2023, we get the Sackett case, getting rid of the significant nexus test, applying a narrow interpretation of the Clean Water Act. And by the way, we get language about how this program really adversely affects private property rights, because it takes quite amount of time to go through the permitting process, and it can take hundreds of thousands of dollars. Mind you, there are studies that show the otherwise or show something entirely different, but effectively it showed how a narrative can get translated into a Supreme Court dialogues, and then that dialogue can help, if you will, influence the ultimate decision. So when we look at the Sackett case, and I've really probably butchered aspects of the history because I could go on for like hours on this, but if you look at what the court did, it's more, I think, significant, not just that it effectively narrowed the scope of the Clean Water Act and might have affected anywhere between 17 and 90 million acres, no longer jurisdictional under the Clean Water Act. And by the way, many of those are in the western area of the country. But also, it reflected how the court can get influenced by a narrative, and the importance, if you will, of a narrative, particularly the narrative of the property rights aspects, if you will. And I want you to think about going back to when I talked about the Sackett case. In the Sackett situation, almost all the other landowners got permits. And the studies out of the Idaho group suggested that if the Sacketts had wanted to, it would have taken them less than a year, and it would not have cost them that much to get their permit. So a lot of what we're talking about is an effort to try to figure out, if you will, how this sort of narrative can get, if you will, put into a Supreme Court opinion that really then impacts the legal analysis. And so from my perspective, and this is sort of, I guess, ties in back to where I started about stories and if you will, the importance of narratives, is that the narrative counts as much, if you will, as the ultimate legal analysis of what the Supreme Court did in the Sackett case. So given the fact that I've been out of time, I'll now take questions. And, probably if you have questions about anything I skip, that might be good too.
All right, does anyone have any questions they want to ask? If not, we can ask some that were online that we got. Okay, all right. We've got a question from online saying, following Sackett's decision, do you think Congress can and should statutorily refine the Clean Water Act's definition of waters of the United States?
I mean, it's a really good question. I mean, one of the reasons we're at this point right now in the wetlands program is in the Rapanos case. Chief Justice Roberts said, let's do a rulemaking. Because up until then, we really didn't have an adequate rulemaking that fully fleshed out the scope of the Clean Water Act. And, so what Roberts was really enticing the agencies to do, which ultimately led, I guess my slides are gone, but, in one of those slides, if you will, I had a picture of the various rulemakings. And so he really did suggest we ought to do rulemakings. And so obviously you saw, I guess it's not coming back, but you obviously saw that we had rulemakings during each one of the administrations, the Obama administration, the Trump 1 administration, the Biden administration. And now we have, after the Sackett case in March of this year, the Trump administration has issued sort of guidance on what it wants to do. So we have seen a flip-flopping from Obama to Trump to Biden to Trump. And so with all that said, if you're asking whether or not we can really address this in Congress, that's a really tough question because the administrations are constantly flipping on their even ability to get a regulation out there that has some durability. And the ability then to get Congress to weigh in is going to be really problematic. We have looked at amending a variety of these programs, and NEPA was the only one most recently that was amended, but even that was not amended. I wouldn't say it wasn't amended significantly in terms of jurisdiction, if you will. So from that perspective, the odds or the ability in Congress with its polarization right now to really amend the definition would be really problematic. The other thing is that, when Congress passed the Clean Water Act, it deliberately included a definition of waters in the United States. It decided to abandon navigable waters as a term of art, okay? And that was clear by the 1977 legislation. So, if you're asking, should Congress come in and tinker again, we have to appreciate that Congress tried to express an intent in the legislative history to the 1977 amendments, and that didn't go so well. So.
Thank you. We've got another one saying that when thinking about how continuous surface connection test applies in the West, what are some of the challenges given the unique features of the West?
Well, I think you have a lot of features that are, you have swallows and you have some other areas. You have areas that are only wet and very unique and short periods of time. I remember when my friends got caught in a huge, if you will, downpour in southern Utah when they were trying to map some areas. So it was wet for about a week with running water that they couldn't even get through. And so the West is a little bit different in that respect. In part because we have more times of dry, if you will, waterways. I've worked on the Platte. And we all know what happens to the Platte in the summer, particularly down in Nebraska, if you will. So when you take a look at the West, it is a lot different than the East. And so I think when you take a look at what the Sackett case is going to do, that's why a lot of the recent studies are suggesting that the likelihood is that it'll have the biggest impact in the West because of the nature of the Western landscape.
All right, last question that we'll do, and then we can take a break before Professor Kalt comes on, is to what extent do you think the states and tribes will fit into the jurisdictional vacuum created by the Sackett decision?
Well, we have seen some states, like Colorado recently amended its wetlands law. And so we've seen a number of states really begin to do that, and you've seen some studies talking about the effort of the states to step in. The answer is it's uncertain. According to at least the latest reports, and again, this is really unfolding, but the latest reports suggest that the states some of the states are attempting to do this, but it's not clear that it's going to be robust enough. As for the tribes, obviously the tribal issue is going to be a little bit different because, if you will, tribal nations have the ability, obviously, to regulate and address their own water quality and water issues. There was a major change in the water quality program during the Biden administration to sort of promote, if you will, the effort of tribes to regulate and address water pollution, if you will, and concerned about water pollution in Indian country. So I think the biggest issue might, though, be that we really do need to figure out how we're going to deal with it on a federal level, because you're going to have not uniform efforts across the states. And so I think that what that's going to do is it's going to create an unfair, if you will, incentive, or just it's going to create an uneconomic level playing field, or not a level playing field in various areas for development. So,
all right, let's give one last round of applause for Professor Kalen.